Hello, and welcome to the first part in our video series introducing you to Ohio Mock Trial. My name is Ryan Susky. I'm the Director of Programs at the Ohio Center for Law-Related Education, the group that sponsors mock trial here in the Buckeye State. As I mentioned, this video is part of a series intended to give new advisors and returning advisors a couple of refreshers that we hope will make the mock trial process easier. If you'd like to view the rest of the videos in this series, you can visit our YouTube page at youtube.com/OCLRE or visit our website at oclre.org. So let's dive right in and ask the question, what is a trial? Or more accurately, we're really going to start by asking the question, why a trial? In his influential book, Start With Why, author Simon Sinek told us that the best understandings and explanations come when you start with why. Understanding the why behind a process is ultimately going to influence the how and the what of that process. So why a trial? Well, at their very core, a trial is intended to be a process to getting to the truth of what really happened. It's adversarial because both sides are going to have a different version of events, and the trial process is designed to give us some certainty about that truth. When you peel back all the layers of the onion, a trial is ultimately meant to be a process to pull out the truth of what really happened. At the end of the day, the decision maker in a trial wasn't actually present for the events that are alleged, so the trial process, all of the rules and procedures that exist, are there to make sure that we can have some level of certainty as to what actually happened at the events that are alleged. Now, this matters a lot when you get down to it, because trials make sure that the state is not leveraging their power arbitrarily. Take, for example, a criminal case. In a criminal case, you need to have some level of certainty, and in this instance, it's beyond a reasonable doubt, that the person who's being accused of something actually did the thing of which they're being accused prior to stripping away their liberty interest. Otherwise, the state could simply accuse anyone they wanted of some wrongdoing and not have any requirement that they proved any level of certainty. In a civil trial, the bar is still high but somewhat lower, and it depends a bit based on what the wrong is that's being alleged, but it's usually what we call preponderance of the evidence, or more likely than not. We set that bar there to make sure that the state isn't using its power to make someone lose their property unjustly, because ultimately, bringing a civil suit against somebody is asking for the power of the state to help you collect money that's owed to you, or some property interest that is owed to you. We want to make sure that the state isn't able to just arbitrarily make that decision, so trials have a process that's set up to get closer and closer and closer to the unknowable truth of a certain situation. So now that we understand a bit more about why trials are structured in the way that they are, we can look at how trials are actually set up. We said before that trials are meant to be adversarial. We've got two opposing sides. In a criminal case, for example, it's the state against the defendant. In a civil trial, it might be two private parties. The existence of an adversary pushes each side to present only their best and most reliable information. The competition aspect of it is what makes both sides bring their A game to the story. Each side is going to work to persuade the arbiter that their version of truth is the one that's correct or most reliable. Now, trials are governed by a series of rules or procedures that we call due process that make sure that they operate efficiently and systematically. And if we go back to that why before of trials being about getting to the truth, then it makes sense that all of these rules and procedures are going to create a system in which we have some reliable outcome. So the rules of evidence, for example, are going to favor true information, and they're going to mitigate the impact of false or unreliably true information. The burdens of production and the burdens of proof ensure that the party asking the court to do something is going to be the one that has to work hardest to ensure that outcome. And the operation of a trial is set up in a way that you can have some consistency and predictability by looking to prior trials, or what we call past precedent. All of these systems, rules, and procedures are set up to advance that purpose of trials being ultimately about truth. Now that we have a better understanding of the why and the how of trials, we can finally get back to our original question. What are trials? Trials can be thought of as being composed of two pieces: evidence and argument. Evidence are the unconnected dots that provide information about what actually happened. Evidence can be demonstrative, right? Reconstructions or representations that show what the original looked like. Real, which is the actual evidence, right? The actual bloody knife, the fingerprints on the murder weapon, the DNA results. Testimonial, meaning what witnesses say at trial, and documentary, which is exactly what it sounds like, a document that provides information about what happened. Now, it's important to know that of those four kinds of evidence, mock trial does not permit demonstrative evidence, but real, testimonial, and documentary evidence is permitted. But all of these dots are unconnected and don't actually lead to any specific outcome until you introduce the second element of trials, argument. Argument is the story that an attorney tells to organize and connect all of the dots, all of the various pieces of evidence. Without argument, evidence can't tell a story. So attorneys use argument in the order in which they present the pieces at a trial, the witnesses they call, the way they connect up the dots to lead the fact finder to decide whether or not to convict, to decide whether or not to find for one party or the other in a civil case. So if trials are composed of evidence and argument, there are going to be a couple of different parties involved who decide what to do with that evidence and argument. The first party you have in a trial is the fact finder. This is the person or people who decide questions of fact. Now, usually that's going to be a jury, but sometimes in what we call a bench trial, it's the judge. Questions of fact are things like, should the defendant be found guilty or innocent or acquitted, right, of the crime that they're alleged to have committed? Or does the defendant bear the responsibility for some alleged civil infraction? This is different from the arbiter, who's deciding questions of law, enforcing the rules and the process. And usually in a trial, that's going to be the judge, though sometimes it might be an arbitrator that the sides have hired to resolve a dispute, or it might be, for example, in an agency hearing, some administrator. You can think of the arbiter kind of like the umpire in a baseball game. They're calling balls and strikes and making sure that the rules of the game are being followed as the other players present their case. The people presenting the case are going to be the advocates, who present the evidence and arguments. Usually there's at least one advocate per side, though it's not uncommon to have multiple attorneys presenting any one side of the case. And the last people, who are probably the most important overall, are the litigants, the people who have a vested interest in the outcome. In a criminal case, the people, right, the state, are the litigant against a defendant. In a civil trial, the litigants are two involved parties, one person bringing suit against another person. If you understand the why of a trial and you help your students understand the why, it's going to make a lot of the trickier parts in this process seem much easier and frankly a lot fairer. Evidence rules just make a lot more sense when you start with why. Remembering that trials are ultimately about getting closer and closer to reliable truth, then you could start seeing the evidence rules as being created in a way that preferences reliable information and discounts or excludes unreliable information. Procedural elements of a trial and the order in which those procedural elements occur is a lot more logical when you start with why. If trials are about convincing a fact finder of truth, then it makes sense that the person who's asking for some outcome goes first in their opening arguments and their witnesses. If the person who's making those arguments has a higher burden to reach because their information needs to be more reliably true, well, it makes sense that we would give them an extra bite at the apple via the rebuttal process. That's all for this segment. If you enjoyed this video, be sure to like or subscribe, and check out our YouTube channel for additional tutorials. Thanks for watching, and we'll see you next time.